Pleasant day to each and everyone. So today I will discuss some of the topics of our subject with the course code of Criminology 5, and the title is Juvenile Delinquency and Juvenile Justice System. So first, let me introduce to you the subject or the course, or what do you expect to learn on this subject. So this course or this subject critically examines juvenile delinquency and the juvenile justice system. Okay, so you will be exposed to some of the theories that will help you understand the development of juvenile delinquency within the context of individuals, families, and communities, as well as the different factors that causes juvenile delinquency, which can enable you later on to create a criminological research about juvenile delinquency. So aside from that, we will tackle some of the significant cases in relation to juvenile delinquency and juvenile justice system. Okay, so you will also able to recognize the various laws and its provisions that protect the rights and welfare of children, as well as the laws that governs the delinquent act or behavior of a child, such as Presidential Decree 603, Republic Act 9344, RA 10630, and other laws. And lastly, in this subject, we'll also examine and determine the role of different agencies such as the PNP, DSWD, and others in handling child in conflict with the law. So let's start first our discussion with the term juvenile. So the term juvenile is synonymous with the term child. And in the Philippines, instead of using the word juvenile, Philippine laws made use of the word child. And as defined in Republic Act 9344, child is a person below the age of majority, which is 18 years of age. And class, before kasi, the age of majority is 21 years old. But by virtue of Republic Act 6809, it amended the Executive Order 209, which is the Family Code of the Philippines. And this amendment lowered the age of majority from 21 years old to 18 years old. Then next, we have the term juvenile delinquency. So juvenile delinquency, defined as antisocial acts or behaviors committed by minors which are contrary to the norms of the society or the community. So simply, juvenile delinquency are any acts or behavior of a child that is not acceptable because it deviates from the normal pattern of our rules and regulations. It deviates from customs or it deviates from our custom and cultures. And juvenile delinquency or this delinquent act of child includes misdemeanor. So when we say misdemeanor, these are the acts in violation of our ordinances, either city ordinances or municipal ordinances. It may also include also offenses. When we say offenses, these are those violations of our special laws. Special laws are those Republic Acts, Presidential Decree, Executive Orders, and others. So the juvenile delinquency may also include felonies. So when we say felonies, it is the violation of our revised penal code. And generally speaking, okay, this child adjudged to be delinquent are called as juvenile delinquent. So don't be confused. Juvenile delinquency refers to the illegal acts which is committed by a child, while juvenile delinquent is the person or the child itself who committed the deviant acts. But here in the Philippines, class, take note, Republic Act 9344 provided that juvenile delinquent can be now called or termed as child in conflict with the law. So the use of the word juvenile, juvenile delinquent, youthful offender, or other similar terms against the child is considered as labeling or shaming punishable under the said law. So next, let us differentiate crime and delinquency. Okay, so generally speaking, crime and delinquency are just the same in a sense that this refers to illegal or deviant acts, and we can use this term interchangeably in our day-to-day conversation. But specifically speaking, crime is an act that breaks our criminal code or the written laws which is created by society through our legislative body. While delinquency is an act that merely break cultural law or the norms or unwritten laws or norms of our society. And crime is an act committed by an adult, while delinquency is an act committed by minors, specifically termed or known as juvenile delinquency. And a person who committed a crime can be dealt with in accordance with the criminal justice system. And a child committed juvenile delinquency will be under the process known as juvenile justice system. So that are the differences between crime and delinquency. So let's proceed to the history of juvenile delinquency. So first we have the Code of Hammurabi. So the Code of Hammurabi was one of the oldest and most complete written legal codes and was proclaimed by the Babylonian king Hammurabi. So this Code of Hammurabi used by their society to regulate behavior and at the same time punish those who disobeyed the rules. So it is the origin of the legal principle of lex talionis, which means an eye for an eye and tooth for the tooth. So through this code and during this time, the General Court of Massachusetts passed the Stubborn Child Law, in which one of its provisions is that children who will disobey their parents could be punished by death. So that is Code of Hammurabi. Then next we have the Roman law or the canon law. So it is the legal system of the ancient Romans that includes written and unwritten law, which is based on their tradition or traditional law and the legislation of the city of Rome. And in terms of the provision in relation to children, Roman law made distinction between juvenile and adults based on the notion of age of responsibility. And then next we have the ancient Jewish law. So based on one of the provision of ancient Jewish law that was written in the book of Jewish law known as the Talmud, so immaturity was considered in imposing punishment, and immaturity of one person was based on their age. So in this provision, no corporal punishment will be imposed prior to puberty, which is 12 years old for females and 13 years old for males. When we say corporal punishment, by the way, this refers to physical punishment that can cause physical pain or suffering to one offender. Example of these are whipping, flagellation, and other physical punishment. And another provision of the ancient Jewish law is that for those below 21 years of age, there will be no capital punishment or death penalty or death punishment to be imposed. The next we have the Codification of Roman Law. So the 12 tables or the law of the 12 table was a set of laws inscribed on 12 bronze stones created in ancient Rome. So a committee of 10 men called the Decemvirs was established in 451 BCE to write down or codify the law for the first time. So the work they produced in 449 BCE the 12 tables documented the centuries-old customary laws and became the foundation or the codification of Roman law. So the 12 tables touch many areas of law, not only the civil law that applied directly to citizens, but also areas such as public law and religious law, which apply to larger social contracts and institutions. So as well as law in relation to children, wherein accordingly, children who are 7 years old below are classified or called as infants or proximus infantiae. And if this child having this age committed deviant act, they were not held criminally responsible or they are being exempted from any criminal liability. In other words, those children naman approaching puberty, which is above 7 to 14 for boys and above 7 to 12 years old for girls, their liability was based on their capacity to understand the difference between right and wrong. So that is the codification of Roman law or the 12 tables. Then we have the Anglo-Sanction Common Law. So Anglo-Sanction Common Law is a body of written rules that was based on only on their customs and tradition and were codified and placed during the Anglo-Saxon period in England. So under this law, okay, children under the age of 7 were presumed incapable of forming criminal intent and therefore were not subject to criminal sanctions. Simply means they are exempted from any criminal responsibility or liability. So, while those children naman between 7 to 14, not considering their gender, were not also subject to criminal sanction unless it could be proven that they had already formed criminal intent and they understood the consequences of their action and could distinguish right from wrong. And those children over 14 years old naman were treated much the same as adults, meaning they are totally criminally liable if they have proven that they committed a crime. So during this period naman, on the middle of 19th century, there was a movement initiated which they called them as the child saving movement, wherein some concerned citizens formed a social activist group which they called as child savers, who believed that children were born good and became bad. Accordingly, juvenile delinquent are not born, but they are made and influenced only by their bad environments. And for them, the best way to save children was to get them out of bad homes and place it in good ones. So, thus, this lead to the creation of the doctrine of parents patrae. So, what is parents patrae? So, this doctrine that does not consider delinquent act as criminal violation, thus making juvenile delinquents non-criminal persons and cannot be found guilty of a crime and punished like an adult criminal. Because this doctrine viewed minors who violate the law because they are victims of improper care, custody, and treatment at home. So parents patrae means that the state becomes the father because it is a doctrine that allows the state to step in and serve as a guardian for children. So we have the Poor Law Act of 1601. So this law provided for involuntary separation of children from their impoverished parents, and these children were then placed in bondage to local residents as apprentices. Then in the Philippine setting naman, juvenile delinquency cases was first governed or regulated by revised penal code. So during this period or during this time, distinct circumstances of a delinquent are not taken into account because as young as 9 years old and above can be incarcerated inside the jail. Meaning and accordingly, most juvenile delinquents before were not segregated from the hardened adult criminals. So there is no diversion, there is no provision of aftercare. Thus, accordingly, some of these child, after their release, they went back in the street with more knowledge of crime. So for your information lang, though it's not already applicable and enforceable, this is the provision of revised penal code in relation to the age of criminal responsibility of children. So if a person before is under 9 years of age and committed a crime, they are totally criminally exempted, as well as those person who is 9 and over 9 years of age and under 15 who committed a crime will be totally exempted unless he or she has acted with discernment. So that is the provision of revised penal code. Then we have the Presidential Decree number 603, or otherwise known as the Child and Youth Welfare Code. So it was signed into law on December 10, 1974 by former President Marcos and became effective 6 months after its approval. So this code provided in Chapter 3, Articles 189 to Article 204, the care and treatment of youthful offenders from the time of apprehension up to the time of termination of the case. So also under this law, those child over 9 but under 21 years of age at the time of the commission of the offense who committed a crime is known as youthful offender. And the provision of this law in terms of the age in determining the criminal responsibility are as follows. But take note, however, that this is not already applicable and enforceable because this provision had been amended already. So this is the provision of PD 603. A child who is 9 years of age or under at the time of the offense shall be exempt from criminal liability and shall be committed to the care of his or her father or mother or nearest relative or family friend in the discretion of the court and subject to its supervision. The same shall be done for a child over 9 years and under 15 years of age at the time of the commission of the offense, unless he acted with discernment. And if the child is 15 and above, they are already criminally liable. Then later on, Presidential Decree 1179 was enacted, wherein it amended some provisions of PD 603, whereas based on this law, some of the provisions of PD 603 which deal with youthful offenders are deficient or ambiguous. And one of the provisions that was amended is the definition of youthful offender. So in this law, a youthful offender defined as a child, minor, or youth, including one who is emancipated in accordance with law, who is over 9 years but under 18 years of age at the time of the commission of offense. So that is PD 1179. Then we have Republic Act 9344, or the Juvenile Justice Act and Welfare Act of 2006. So it is an act establishing a comprehensive juvenile justice and welfare council under the Department of Justice. But take note, later on the year of 2013, Republic Act 10630, an act strengthening the juvenile justice system in the Philippines, was enacted. And it amended some provisions of Republic Act 9344. And one of these amendments is that it placed the Juvenile Justice and Welfare Council under the Department of Social Welfare and Development, or DSWD. And the provision of Republic Act 9344 naman, in terms of the minimum age of criminal responsibility, is that a child who is 15 years of age or under at the time of the commission of the offense shall be exempt from criminal liability. And as provided and added by Republic Act 10630, a child is deemed to be 15 years of age on the day of the 15th anniversary of his or her birthday. So, on the other hand, a child above 15 years but below 18 years of age shall likewise be exempt, okay, from criminal liability unless he or she acted with discernment. When we say discernment, it is the capacity to understand the difference between right and wrong and its consequences. Okay? And we take note further, as per the IRR, or the implementing rules and regulations of Republic Act 10630, we can say that the child is above 15 years of age if the child is at least 15 years and 1 day old. Also, under Republic Act 9344, this child who is alleged as, accused of, or adjudged as having committed an offense are termed or called as child in conflict with the law. So that is Republic Act 9344 as amended by Republic Act 10630. So let's proceed now to the personalities and dates in relation to juvenile delinquency. So first we have Pope Clement XI. So Pope Clement XI established the hospice at San Michel, or can be known as Hospital of Saint Michael. So it is a large and noble structure in which one of its portion or building is for orphans or destitute. And another part of the hospital is a prison called as House of Correction for boys or young men who committed illegal acts. And furthermore, it is considered as the first institution for treating of juvenile offenders, okay, in which the stated purpose of this institution was to correct and instruct unruly youth so they might become useful citizens upon their release. Also, it is the first house of refuge in the whole Europe because, as I mentioned before, it was made as a charitable institution for giving shelter and protection to the homeless or destitute children. Then, sino naman si Robert Young? So, Robert Young established the first private separate institution for youthful offender in England naman on 1788. So, its primary goal or the primary purpose of this private institution was to educate and instruct some useful trade or occupation the juvenile delinquent or such other poor children who were engaged in a vagrant or yung mga pakalat-kalat or yung mga namamalimos and criminal course of life. Then next we have Albert Cohen. So Albert Cohen was also a prominent American criminologist, just like Edwin Sutherland. So he received the Edwin Sutherland Award from the American Society of Criminology for his outstanding contribution to criminological theory. So Albert Cohen, known for his delinquent subcultural theory, one of the classification of strain theory. And through this theory, he was the first man who attempted to find out the process of beginning of the delinquent subculture, wherein according to him, according to this theory, delinquency is the consequence or response of children in expressing their frustration toward the norms and standard of middle class in which hindi nila kayang makasabay. Means those youths belonging to lower class families generally lack the means to achieve such social status, and leaving these lower class children less equipped for satisfying the standards of middle class life. Thus, the choice is to disregard the conventional norms of what this middle class have through forming their own culture, forming their own group or a gang. And these gangs will be the reflections of lower class subculture. And in this subculture, they can do what they want to satisfy their wants and needs as to the extent that it is already illegal. So we have the important dates in terms of juvenile delinquency and juvenile justice system. So the first juvenile court or family court was established in Cook County, Illinois, and it was on 1899, wherein the Illinois legislature passed a law establishing a juvenile court or family court that became the cornerstone for juvenile justice throughout the United States. And the period between 1899 and 1967 naman has been referred as the era of socialized juvenile justice. So during this era, children were considered not as a miniature adults or little adult, but rather as persons with less than fully developed morality and cognition. So during this period, emphasis on determining how and why the juvenile develop delinquent behavior and commit illegal acts, and how to treat and rehabilitate the juvenile became one of the primary goals of every institution handling juvenile delinquent. And during this period also, prevention and removal of the juvenile from undesirable social situation were the major concerns of the court. So during this era, from 1899 to 1967, or the socialized juvenile justice period. So let's proceed to some of the House of Corrections for juvenile delinquent. So first we have Pridewell. So originally, Pridewell was built as a royal palace for Henry VIII in 1515. So it was called as Pridewell Palace before. And on 1553, it was given to the city of London. Thus, Pridewell made as prison and became the first house of correction, both for adult and children in England. So it was both first house of correction in the country and a major charitable institution, because its main purpose or function is to incarcerate disorderly or deviant, both, as I mentioned before, both adult and children. And it houses vagrant or homeless children. Therefore, the term Pridewell, or furthermore, the term Pridewell, subsequently became a common name for jail or prison, used not only in England, but also in other English-speaking cities or English-speaking countries. Then next we have the Hospice of San Michel, can be known as Hospital of Saint Michael, or some call this as Saint Michael. So this prison or this institution was considered to be one of the ideal model of prison institution at the time. Thus, it was brought to the attention of the English-speaking world by the great prison reformer, namely John Howard. So, John Howard is a Christian activist and who was often thought as the father of prison reform. So, his work, he inspected different jails in order to ensure that prisoners receive humane treatment, and this work led him to brought this model and practices of Saint Michael from Rome to England as the first institution for treating juvenile offenders. Then we have the House of Refuge. So the New York House of Refuge was the first juvenile reformatory and thus considered as the oldest established reformatory in the whole United States. So it was open to house juvenile delinquents, in which juvenile delinquents, as defined for them as youths convicted of criminal offenses or found in vagrancy. House of Refuge in New York started only with confining 3 boys and 6 girls. And later on, the number of children rapidly increases. So the age of admission on this institution are from 8 years old to 17 years old. So the boys are divided into sections in this institution called the North and South divisions. So the North division consisting of the boys of more vicious or violent character. And then the South division, on the other hand, composed mostly of younger and non-violent boys. Then we have Kingwood Reformatory. So this reformatory, the Kingwood Reformatory, was established for the confinement of the hordes. When we say hordes, it's a group or a large group of unruly children who already infested, when we say infested, invaded the streets of new industrial towns of England. Then next we have some of the significant cases concerning juvenile delinquency. So first we have the Ira Windshield case. So in 1967, by the name of Samuel Winship, who was 12 years old at that time. So this is the story of Winship. He stole from a purse in a locker. Then he was charged in the New York Family Court as being a juvenile delinquent. So under the New York law at the time, a juvenile delinquent included any person between the ages of 7 to 16 who committed an illegal act. Kaya pasok si Samuel Winship. And relying on the New York law, the family court or the juvenile court judge found that Winship is guilty by preponderance of evidence. And for your information, the preponderance of evidence standard is much easier to meet than the proof beyond reasonable doubt standard. So Winship then appealed his conviction to the New York Court of Appeals, arguing that the due process clause of the 14th Amendment of United States required the prosecution to prove that he committed the crime he was charged with beyond reasonable doubt standard. So the New York Court of Appeals rejected Winship's argument. Thus, he appealed this decision to the U.S. Supreme Court. And then Supreme Court ruled out that his conviction of a crime in a juvenile delinquency proceeding was unconstitutional because the court did not prove that he committed the crime beyond reasonable doubt. Thus, he was acquitted. And because of this case, the Supreme Court decided, so ito yung pinaka-significance dito sa case na to, the Supreme Court decided that in juvenile court proceedings involving delinquency, the standard of proof for conviction should be the same as that for adults in criminal court, which is proof beyond reasonable doubt. And the proof beyond reasonable doubt standard is the highest standard of proof that may be imposed upon a party at trial. And it is the standard used in criminal cases. Proof beyond reasonable doubt means the proof that is close to an absolute certainty. In other words, if the judge or has any doubt and is not certain that the accused is guilty after looking the pieces of evidence, then he or she must be acquitted. Then we have one of the case, the Breed versus Jones. So in the case of Breed versus Jones, it was on 1979, wherein a 17-year-old respondent, namely Jones, was adjudicated in juvenile court to have committed acts that would constitute robbery. So after the juvenile court hearing, the court determined that Jones should be tried as an adult in criminal court for the same robbery offense. But later on, to cut the story short, the U.S. Supreme Court granted certiorari or writ of certiorari, and accordingly, in this case, the double jeopardy violation is clear when Jones was subjected to 2 trials for the same offenses. He was forced twice to defend the same charge filed by the state, and he was forced twice to deal with the personal strain of being tried for the same crime. Thus, this landmark case, Breed versus Jones, ruled out or laid down that trying a juvenile who had previously been adjudicated in juvenile court and trying for the same crime as an adult in criminal court will constitute or violates the double jeopardy. So according to U.S. Supreme Court, a juvenile court proceeding is the same as an adult criminal court proceedings in many respects. Then we have in re Galt. So on 1967, the U.S. Supreme Court handed down a decision in the case of Gerald Galt, a 15 years old juvenile from Arizona. So Galt was accused of making an obscene phone call to a neighbor who identified him. So the neighbor did not appear at the hearing, and it was never demonstrated that Galt had in fact made the obscene phone call. Neither Galt nor his parents were notified properly of the charges against their son. They were not made aware of their right to counsel, their right to confront and cross-examine the witnesses, their right to remain silent, and still, despite of these loopholes, at the conclusion of the hearing, the judge committed Galt to juvenile detention for 6 years until he turned 21. Then Galt's parents filed petition for a writ of habeas corpus, which was dismissed by both the Superior Court of Arizona and the Arizona Supreme Court. And then the parents of Galt sought relief in the Supreme Court of United States. So the court agreed to hear the case to determine the procedural due process rights of a juvenile criminal defendant. And then the Supreme Court ruled that even Galt is a juvenile at the time of his arrest, he would have been afforded the following procedural rights or safeguards as the same with adults. So as you observe, decisions in the case of Jones, Galt, and Winship, it made clear that juveniles charged with delinquency have most of the same rights or procedural rights as adults trying in criminal court. Then we have the American Bar Association. So this association endorsed the decriminalization of status offenses, or meaning status offenses should not be punishable according to American Bar Association. So urging that juvenile delinquency liability, or it should only be punished if the acts include only such conduct as would be considered as crime if committed by an adult. In juvenile cases, when we say status offenses, it involves conduct that would not be a crime if it were committed by an adult. In other words, the actions are considered to be a violation of the law only because of the youth's status or as a minor. So common examples of status offenses include underage drinking, skipping school or truancy, and violating a local curfew law. Then we have the Skull versus Martin. So Skull versus Martin is the first time, it is the case wherein the courts the first time sanctioned detention of an individual prior to a finding of guilt for a purpose other than to ensure that the person will appear at trial. In Skull versus Martin, the Supreme Court upheld a New York statute that provided for the preventive detention of juveniles accused of a crime who present a serious risk that they may commit another crime before trial. So when we say preventive detention, is the practice of incarcerating accused before trial on the assumption that their release would not be in the best interest of society, specifically that they would be likely to commit additional crimes if they were released. So on the last, we have types of delinquent youth. So we have social, neurotic, asocial, and accidental delinquent youth. So first, we have social delinquent youth. It refers to aggressive teens or youth who resent or hate authority, whether be it parental or school regulations. Then the most common reason for such dislike is focus on anyone who tries to control their behavior. Meaning, these are those delinquent youth na ayaw silang kinokontrol or kinukuman. And then we have the neurotic delinquent youth. So these are types of delinquent naman who have internalized their conflicts and preoccupied with their own feelings. Meaning, they are the delinquent whose delinquency is the result of powerful unconscious impulses. They characterize by serious emotional disturbances within the individual and in some cases associated with tendencies towards mental illness. So their delinquent act is sometimes considered symbolic. For example, if this delinquent youth is steal, it is done for love and not for material gain. So it's symbolic. To such delinquency is a way of handling their internal problems by externalizing the problem within the environment. Then we have the asocial delinquent youth. So these are those delinquent youth whose acts are manifested by vile, cruel, and atrocious or terrible acts and conduct for which they feel no remorse or they feel no regret on the illegal acts they committed. So this type of delinquent youth are usually having weak ego, and factors of this why some youth become this kind of delinquent because of their early experience severe parental rejection. So they have poor personal relations and suffer general isolation. And then lastly, we have accidental delinquent youth. So this type of delinquent youth, their personality and temperament are less identifiable. Essentially, they are a law-abiding citizen, but happen to be at the wrong place at the wrong time and becomes involved in some delinquent act in which is not their typical or general behavior. Sometimes this type of delinquent youth may be attributed to peer pressure or pure curiosity, especially they are still young person. So that's it for today. So just wait for another video discussion on our subject. So, thank you.